So welcome back. Now we will get into more detailed provisions of arbitration. Let's begin with understanding how interim reliefs in arbitration are dealt with.
Yes. So the interim relief mechanism, by the current state of the law, the judges have the same power as a civil court would have to grant interim relief. But this is a structural problem in arbitration everywhere, is that even if an arbitrator passes an order for interim relief, the execution of that is still left with the court. The arbitrator has no execution powers or the machinery or mechanism. So the execution mechanism which is there with the court under Order 21's all extensive provisions, that is not there. So again, an application has to be filed in court for executing that order. If
and
it is not
remembered the Privy Council judgment.
Yes, that the problem of when starts after he gets a decree.
I was hoping that in arbitration there could be some mechanism different and some aid in execution, but it is the same.
So it is the same procedure, but usually the courts, like if it is a straightforward order in which simply some deposit of the money has to be done, etc. Then a security for cost, for example, then the court simply execute it. Without getting into it. But way it is our court procedure is such that if anybody applies, then a reply is sought, or in trial courts as we say कि इसमें say दीजिए. Other side का क्या कहना है, and then again the arguments over it, oral arguments over it, and that takes up some time. But you are in a court, and courts usually don't pass ex parte orders without hearing the other side. Then that has to be done. So and sometimes there is it's good that the courts do it because arbitrator can pass a wrong order. They may pass orders way beyond their powers also. So that can happen. So all the safeguards which are there in the execution mechanism, those I think need to be, it's only a court can supervise that. If arbitrators start issuing orders and attach this, attach that, and then it can cause a havoc. So there is, I think it's a safeguarded mechanism, but it's just a wish that courts would not interfere too much in execution of the orders passed as interim relief by the this thing. But if you look at the practical situation, the Section 9, which is the relief giver, interim relief, there is a parallel Section 9 power given to the court to grant interim relief, and that is before the arbitration, during the arbitration, and after the award also.
Okay.
So this is very unique. So a lot of people try that, instead of going for execution, let's file a Section 9 and get some relief out of it. And the unique aspect of this is, the last point in this regard is that in the civil suit, before institution of the suit, no interim relief can be granted. The suit has to be in place for reliefs under Order 38, 39, 40 that can be granted. So attachment, injunctions and receivers, those can be granted only if a civil suit is there. So the suit has to be filed. Then and then only you can move. But here there is no provision like that. Here there is no requirement like that. Section 9 can be invoked even before statement of claim has been filed.
Okay.
Because subject matter of the jurisdiction, the dispute needs to be preserved. So it's an emergency power and all that. But as soon as the arbitration is invoked, the section itself says that the power to grant, the courts would take a backseat and give primacy to the arbitrator. Courts will tell litigants to come during the arbitration to court, go to the arbitrator first, get an order, and then if it's right or wrong, you can appeal it in 37. That is a different thing altogether.
Okay, now about the power or effectivity of the orders of arbitral tribunal. How about the contempt? Is there any chance of contempt?
This is not a tribunal in the traditional sense. The word arbitral tribunal is used in the Act, but it is not a tribunal in the traditional sense. So a lot of people have this idea that this is an arbitral tribunal, so 227 will lie against it. 227 is an overarching power with the courts 226 and 227. Courts can interfere pretty much into anything. In under that this thing in the jurisdiction of the High Court. But courts, rarely do it. Rarest of rare cases, I would say, that the court should
So
do it.
contempt and arbitration is not.
Is not. There is a mechanism where, like a review or appeal is provided for certain orders and not for every kind of orders. Because, see, in the civil system, Order 43 Rule 1A defines, like the appealable orders. But what is not appealable are courts, like have given a mechanism that you can file a 227 against it, an application under petition under 227. So what is not appealable here becomes appealable in a sense, through the 227. But that mechanism is not here. So people still try filing 226 and 227s, but like the courts reject them.
Now there is another concept of competence.
Yes.
So that you can throw some light on.
It's a German word, even competence, but in English it's competence. It's essentially a mechanism where, like the arbitral tribunal can rule on its own jurisdiction. Okay. So if you want to challenge the jurisdiction of an arbitral tribunal, then you challenge it in front of the tribunal itself by making an application before the tribunal itself. Okay. So you don't go to a supervisory mechanism like court to challenge its jurisdiction.
Okay.
So it's the arbitral tribunal which can rule on its own jurisdiction.
And that then, if a party is not satisfied with the jurisdiction, then what is the remedy?
There is a remedy given to challenge, that order and all that. But that, is like in the domain of the courts. The Act provides a remedy.
The Act itself, it is self-contained.
Self-contained in that sense,
Now, you had also mentioned about the interim reliefs. So they also can be challenged.
Yes.
But the scope of challenge is same as much.
No, the challenge is obviously to a court from an interim order, because there is no appellate mechanism built in here. There is a judgment, centro trade, whereby even an appeal mechanism can be built into arbitration. So two-stage arbitration can be built up.
Oh, this is very new.
Yeah.
What is two-stage arbitration?
Yeah. So it's been there since some time. The judgment is older. Around 8 years old. 7 or 8 years old now. But appeal two-stage arbitrations have been recognized. So technically, like a mechanism, and this goes simply to the earlier point that it's very flexible mechanism. You can even build such kind of mechanisms, if required.
Now, that also raises a question, since we are talking about challenge. Can the appointment of the arbitrator itself be challenged?
No, there is no direct challenge mechanism. It's only, the Supreme Court under its overarching Article 136 powers can actually get it. There is no appeal.
So again, a very limited scope.
Limited in the sense that it's completely discretionary, because the Supreme Court does not, admit every application SLP that comes its way.
Now we come to the another aspect of award. You have mentioned it is not called judgment, for arbitrator decides ultimately.
It's called an award.
So can that award be challenged?
Yes, that award can be challenged, and must mention here that there are some special statutes like land acquisition, for example, or the MSME Act, for example, where the arbitration mechanism is given under their rules and powers, but the challenge is given under 34 to the court. So which is the section 34, which is the challenge mechanism here for the awards also.
And the scope of the challenge
is extremely limited. And it is, domestic awards can be challenged under, this public policy exceptions, and public policy is again further defined that it is the fundamental policy of Indian law, and the law has actually gone into lots of topsy-turvies, because let's face it, the courts want some power to interfere in the awards. And because they are courts of justice, we must not forget that. They are not here to rubber stamp the awards. They are courts of justice. So they do feel that something that has become as a challenge before themselves in a first level review, I'm not using the word appeal, but first level review, they do want to, it's sometimes called setting aside proceedings, sometimes called challenge to the awards, but it is first level review. Let's use a neutral word. Courts cannot simply rubber stamp the awards. Where they see that something is really fundamentally wrong, they want a power to interfere. But now they are saying that the debate is, do they have power to modify the awards?
Mm-hmm.
Not, completely set aside, or even partially set aside. Partial setting aside was not a problem. That this will not, severance was not a problem. but can we interfere and replace the parts of the award? Courts have been doing it on and off, let's face it, I mean, like under 34 itself. But the legislature has been trying to control them, because as soon as you say that this part you can modify, then what is there to say that you cannot modify the whole award? Then you know what? Then it essentially becomes an appeal on fact and law.
Yeah, that is what I was also, coming to, like, appeal is kind of continuation of trial.
First appeal is continuation of trial, and
but same principles can't be applied.
It is de novo, as the Americans use the word. It is de novo review of facts and the law. And we say, in fact, that the lower court order merges into like the higher court's order as such. I mean, when you have a first appeal which decides on a judgment or a decree, that merges and that replaces everything that has been done by the trial court.
But that is not so.
That is not the mechanism here. It's a fundamentally different mechanism.
And it is also a good thing.
It is a good thing because otherwise arbitration's goal is certainty. That it is. That's why they said that it's the final award. There can also be an interim award.
Okay.
So just like there can be a preliminary decree for some things like partition and partnership and all that, there can also be an interim award.
Achha.
And that also is challengeable in 34 in some way. But it's minor. So for example, in construction disputes, two aspects are separated. Whether there is a liability on certain party, employer or the contractor. The person giving the contract is called the employer, although the word sounds odd, but it's called the employer. So the liability is on whom? And then the second part of the review is the quantum part of it.
Okay.
That alright, there is a liability, but how much is the liability? So that part is called quantum. So these two aspects can be bifurcated. So arbitration in internationally also there can be two phases to it, the arbitration. One is decide the liability and other decides the quantum. And you need different kinds of experts and different kinds of submissions and pleadings for both the aspects, I think.
Okay.
So, because the liability goes to costing, quantum is the costing aspect of it. But what is the cost of, this particular liability? Liability essentially is a legal determination whether liability exists or not. But without getting into disputes of it, those are the mechanisms where an interim award could be useful.
I think we have come to know about so many nuances in this challenge and this arbitration, and I must say that since the overall scope of challenge is limited, it is an advantageous.
It is advantageous because we need finality. That is the main thing. Because if it goes on into appeals, then what is the purpose of creating arbitration? Because as a parallel mechanism to courts, if it is going to run in the same manner.
Especially after the award also, the execution proceeding is another challenge.
Execution proceedings are still with the court. There is no private execution mechanism which is available. So that we must remember that all awards put into execution follow the same execution mechanism of a civil court.
So actually I was going to ask the same thing, like how it is executed, but already that is answered.
That is, there is a clear answer to it. In law we can give very few clear answers. Lawyers love to use the word that it depends. But we don't use the word depends. Their execution is with the courts.
So in the next part now we will also try and understand from Hasit sir about the career aspect in the arbitration field.
Thank you.